The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Last week, our firm, Friedman Vartolo, filed an Amicus curiae brief with the U.S. Supreme Court on behalf of 5 national and state trade groups in support of a challenge to the retroactivity clause of FAPA. Today, I'm joined by Stephen Vargas, Senior Appellate Counsel to the firm, and somebody who is no stranger to the Weekly Friedman.
Hey, Adam.
Steve, thanks for coming back.
And thanks for having me again and talk about this very important development for the firm and the entire practice area.
So you don't just wake up one day and say, I'm going to go file an amicus brief with the Supreme Court of the United States.
You certainly don't.
So what happens? How did you decide what case you're going to file an amicus on? How did it get started? What was the first you heard of this?
Exactly. We were monitoring every appellate court decision in New York from all the appellate courts as well as federal courts on a weekly basis to see if there's any cases that present an interesting holding, interesting facts regarding a FAPA amendment that someone, another law firm, another bank potentially would be interested in trying to petition to the U.S. Supreme Court to hear. It took another entity, another law firm, to agree to make that challenge. You needed someone with an appetite to be that aggressive in litigation. And obviously fees and costs from Supreme Court litigation are high, higher than virtually any other type of litigation you could imagine, even for briefing and motion practice. And you needed someone with an appetite for the risk, an appetite to be the first to challenge at that level. And that's what we were waiting for. We were in touch with various stakeholders, whether it's clients who had maybe had an appetite, other firms that thought they may have had a case that was worthy of a challenge. And ultimately, we found out that another firm in the industry and another note holder, investor in the industry, were very serious about doing this. And when we learned of that, and then they filed their brief. They filed a motion, I'm calling it a motion, but a petition in the U.S. Supreme Court is effectively a motion. So it's a petition/motion for permission to have the Supreme Court take the case and consider whether the New York State Appellate Division correctly ruled on the issue. Once we learned of that, it was a call to action in a sense, where we let all of our clients, we let all of our trade association groups that we're involved with know that now the unique opportunity 2.5 years in the making has presented itself, and we were encouraging them to act and advocate on behalf of U.S. Bank.
So, in essence, you needed this perfect storm. You needed a case, and you needed really kind of the law firm that had handled the case, and the client, probably the plaintiff in that case, to also then agree to go to this next step.
So let's say, hypothetically, there were 100 cases in the last 2.5 years where the appellate courts across the state applied FAPA retroactively. In theory, any of those cases could have been a candidate for these higher levels of challenge, but it also took an investor that had the appetite for putting its name on a brief in the Supreme Court, and to date, none of the other investors across the state, despite losing in the appellate court, losing the ability to enforce high balance mortgages, none of them had the appetite until this year.
Okay, so now you find the case. You have a plaintiff that's willing to proceed. You have a law firm that had handled the case that's willing to proceed. But look, we're not filing this. Friedman Vartolo isn't challenging it.
Correct.
Right?
The law firm's not challenging anything. The law firm's representing.
Right, and we don't have,
groups.
Just to highlight this for some of the individuals watching that might not totally get it, we don't really have standing to challenge. Right?
No, the law firm wouldn't have authority to be litigating. The law firm is just a law firm advocating, filing papers on behalf of another organization.
So we have the case, we have the situation. Mm-hmm. How do we then go about getting the trade organizations or those entities that are going to be represented in this challenge? What happened? How did that come to be?
When we found out that U.S. Bank was going to petition the U.S. Supreme Court to take the appeal. And I'm going to use layperson's terms to an extent about taking appeals and things like that. Once the brief was filed, once their application was filed in the U.S. Supreme Court, we then notified every organization that we are involved with, a member law firm, as well as organizations within the industry, through networking that know of us, that we've met at different times, and brought the issue to them and said, you've been you've had an appetite for a challenge to the FAPA retroactivity clause. You've filed briefs in other FAPA impacted appeals, but never at this level. You've had an appetite to challenge in the intermediate appellate courts. Now this is an opportunity that we didn't know if it ever present itself, and now it has. So the time's of the essence. There's a sense of urgency here, and like I said, I call it a call to action because that's what it was. Reaching out via email, having numerous phone conversations with the various stakeholders of these organizations, board members of the board of directors, general counsel for the organizations, presenting why this appeal could be taken by the U.S. Supreme Court. And admittedly, the vast majority of appeals, petitions are not granted. We feel this is a compelling situation based on the scope of the retroactivity clause and what we believe is an unprecedented indefinite retroactivity clause, or at least how it's being applied by the courts and interpreted by the state attorney general. We thought this was a great opportunity based on good facts, well-written briefs, to bring this issue up. And we said this may be the only time you get to file a brief in the Supreme Court regarding FAPA, maybe even on other issues. It's extremely rare for anybody in the mortgage banking industry in New York to have an opportunity to file a brief.
And then obviously you have to be admitted in the U.S. Supreme Court, right?
Of course.
It's not something we worry about because it's rare you're handling, a foreclosure matter or something within our scope within the Supreme Court. So you actually got admitted in the Supreme Court. That process takes a few weeks.
In our case, we did it via paper, but you actually could go in person to D.C. and get sworn in. They have periodic swearing-in days. But yeah, in anticipation of filing this brief, not only did we have to quote, rally the troops, rally the support from the trade organizations, articulate these strong arguments we intended to make, data gathering, research on journal articles and state-generated data from the New York State court system about foreclosures, mortgage defaults. We also had to go about applying for admission to the Supreme Court, which was a separate responsibility that fell within the firm. But Mike, Zach, and I did that. As soon as we knew that there was this opportunity, we wanted to be ready. So we were admitted to the Supreme Court well in advance of when we had to file the brief because we knew we had to be, we couldn't risk any delay. We were very proactive with it. And as soon as we knew about the potential, that the U.S. Bank was going forward with its petition for writ, we acted immediately to apply for admission to the Supreme Court.
Steve, I really appreciate it. I think this is a really good kind of like behind the scenes look into what goes on when you file an amicus brief, especially something, like FAPA that's so important to our industry in New York. So I really appreciate it. I think you did a great job explaining it.
No, thank you. I appreciate the time, and we look forward to filing more of these across the country as we go forward as a firm.
Let's do it. Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.